All right. Well, I've got 9 o'clock. Let's get started. Good morning, everyone. By way of introduction, my name is Brian Park, and I have the honor of being MMTA's President and CEO. And I want to welcome everyone to this morning's webinar. Today, we're going to be discussing everyone's newest favorite subject, Maine's paid family and medical leave law that has compliance requirements starting in a few weeks, which is why we're all here today. A few housekeeping items before we start. This webinar is intended to give information and set you on the path to compliance with this new law, but it's not intended to replace legal advice on your company's specific circumstances. And as we've told people before, Tim and I might be nice guys, but we aren't the ones that are going to be defending you in court if you get sideways with this thing. So we also want to mention that we encourage you to ask questions through the chat feature, and we'll get to as many as possible after Matthew's presentation. And now to introduce our subject matter expert, Matthew Lamourie is an attorney with Pretty Flaherty in their employment law and litigation groups. His practice is equally divided between management side, labor and employment litigation, and compliance counseling, where he represents clients in court as well as in proceedings before federal and state administrative agencies. Matthew represents clients in a number of industries, including transportation, and he brings a deep knowledge and decades of experience to guide his clients through various workforce management challenges, as well as helping them navigate complex and constantly evolving federal and state employment laws. With that, Matthew, I will hand it off to you.
Do you have the presentation up,
I
Ryan?
do have the presentation.
Okay. Let's see here.
Can you see that?
Yep, perfect. Yeah, that's ideal.
Wonderful.
So next slide. So this is a great opportunity. Thanks, Brian, for the intro. Uh, Pretty much all I do day in and day out as a management side attorney is represent employers in a variety of different settings. So as you can imagine, for the last year, we've been tracking uh, developments toward paid family medical leave. And earlier this year, as all of you know, Maine joined the ranks of, I guess Maine is now the 13th state, unlucky 13, to pass a paid family medical leave act that creates a new benefit for employees. Of course, Maine has always had a family medical leave law. It's doesn't mirror, it parallels the federal family medical leave law. But this new enactment, the one that Brian referenced that I'm going to talk about today, creates a paid benefit. Okay. And previously, in terms of family medical leave, employees had a right to take a certain amount of time off, depending on if they were covered under state law, Maine law, or federal law. But that leave was unpaid. And really the benefits of family medical leave up to this point in time involved certain job guarantees, job protections for folks that took leave and then were prepared to come back before the expiration of their leave. And then, at least under federal law, the employer was obligated to maintain their health insurance coverage in the status quo. Well, now, with paid family medical leave, Maine is moving toward a new format where this benefit, this paid family medical leave benefit, is an income supplemental benefit. So it's going to look more like short-term disability. This agenda that you see up on the screen now is sort of lays out the four broad areas that I'm going to talk about. I'm going to lay out the framework. Many of you have probably already taken steps to get a handle on what the program entails. So after sort of a basic overview, what I'm going to talk about is what's critically important for employers to do between now and January and what they should expect are their obligations as of January. I'm going to talk a little, then I'll switch gears and talk a little bit more about technical issues, premiums, eligibilities. And I'll throw out and answer some questions that I've typically gotten over the past couple of weeks. And then I'm going to talk about 2026 and beyond. Of course, the thing that's important is from an employer standpoint, you have all employers have main employers have obligations that commence January 1, but the program itself, the availability of this paid family leave benefit to employees doesn't go live until May of 2026. And that's purposeful because the state basically is using 17 months of employer contributions and in some cases supplemented by employee payroll deductions to fund the program. Uh, and so, without getting into the policy, the public policy, and the fairness um, considerations associated with why that is, um, there are some things that you have to consider now and focus on now, and the actual mechanics of how the application process will work, eligibility, the undue hardship exception. There'll be plenty of time between January and May of the following year to get into details about that. So with that, let's start with a description of the overall framework. So most of you know that have made efforts to get up to speed on what your obligations are. That, as I said, this is an income replacement, an income supplement program for employees, Maine-based employees who miss work for specified reasons. And for the most part, those specified reasons are the same reasons that have applied in the past under family medical leave rules. Okay, there are a couple of new nuances involved, but as I said previously, that paid time off was that time off under family medical leave was unpaid beginning in May of 2026. If an employee is eligible, we'll talk about the eligibility standards. They can cover just about up to 2/3 of their calculation of average weekly wage up to a cap to make it a little easier for them to get through that leave program, that leave period. The benefit itself can be taken up to 12 weeks, which parallels the federal family medical leave standard. And as I said, as I've alluded to, it covers things like medical leave, family leave, safe leave, which is a leave that's available for victims of domestic violence, or leave related to a family member's military deployment. So broadly stated, those are the reasons in which an employee can file an application for this paid benefit. It covers all Maine-based employees and all Maine-based employers. So let me get into the weeds a little bit initially here, because there have been a lot of questions on, well, who's covered? We have operations in Maine, we have operations outside of Maine, and it's really, and I'll get into this a little later in the presentation, but this benefit is specifically directed for employees who are Maine-based, okay? And there is a sequential 4-point test that the state is going to use to determine whether a person qualifies as a Maine-based employee. In other words, whether the wages generated for an employee so that the person is eligible for paid family medical leave are generated in Maine. The place where the primary place where the work is performed. So if the employee performs all or a majority of his or her work in Maine, they're qualified, they're eligible to participate in this program. If that's not the case, in other words, if you have employees who perform a lot of their work outside of Maine, who may be picking up cargo in Maine, but spending a significant amount of time outside of Maine delivering it, if their base of operation is in Maine, even if they don't perform a substantial amount of work in Maine, if the base of operation is in Maine, then Maine law applies and they're potentially eligible for this program. The third part of the sequential test is if the employee has no base of operation in Maine and no work is performed in Maine, but the service that they perform is controlled or directed from Maine, okay, they're potentially eligible for the program. And then the fourth is place of residence. I truly don't think that in most cases, an employer trying to answer this question is really ever going to get to the third and fourth criteria. I think of the vast majority of employers who are considering, well, who's covered and who's not within my workforce are going to be able to answer that pretty clearly from the first criteria, the second criteria. And then, as I said, there's some very, very important obligations that employers must be familiar with and must be prepared to move on uh, by January 1. And principally, what we're talking about is setting aside the monies that must be remitted to the state in order to fund this program. And those monies, as most of you know, depend the rate, the premium rate that you're required to contribute depends on the size of your workforce. But you must begin setting aside those premiums, all Maine employers, as of January 1. The first remittance date is a little after the end of the first quarter, but in terms of actually running the calculation and setting aside premiums so you can make that remittance in at the end of the first quarter, you need to take some steps and start thinking about what you plan to do now. Next slide, please. So here's a timeline. Here's a big picture view of the timeline. Okay. The law goes into effect January 1, and there are two important implications of that. As I said, employers have to begin setting aside monies for the main program, the state administered program, as of January 1. And we'll talk a little bit about taking payroll deductions, but a portion of the premium contribution rate that employers are required to take can be taken from employee wages, directly from employee wages. But this process, you've got to be up and running by January 1. And along with that is the state has set up a online portal, a website that it's called the Maine Paid Leave Contribution Portal. It's a portal specifically set up for employers for purposes of allowing them to register for the program, to provide data in terms of the size of their workforce, in terms of uploading quarterly reports that are going to be filed, and most importantly, for purposes of remitting these quarterly contributions, these payments that are required into the program. The portal hasn't gone live yet. All indications, the portal has been set up, but the state is stress testing it right now. For all intents and purposes, our understanding is it's going to go live either on January 1 or shortly after January 1. And my strong recommendation to all employers, is that you go onto the portal before January 1, okay, or go into a website that I'm going to provide you some guidance on. Learn how to go through the registration process, explore the features of the portal. So when it does go live after January 1, you'll have some familiarity with how it's set up. Now, in terms of accessing the portal and accessing some very specific and I think well-designed guidance that the Maine Department of Labor has put out, I want to direct you to a website. In terms of having very technical questions answered, your questions about how the program's going to work, the format of the quarterly reports that you're going to have to upload, the contributions, how the program works. The best resource available, far better than any resource that either Brian or I can provide, is is a website that's administered. It's been set up by the Maine Department of Labor. It's www.maine.gov/paid leave, one word, no dashes, no dots, backslash. So www.maine.gov/paid leave backslash. That's going to bring you online to a web page administered by USDOL, pardon me, Maine DOL, and it's the and if you drop down once you're on the opening page, you'll see that one of the first things you're going to see is a little box where you can add a website, pardon me, a URL, your email address on the Maine DOL's Get Notified list. And I think it's really important to do that. It can be any email address. Ideally, it should be your whoever manages your HR, the owner of the business. Anybody can add their email address. And by adding the email address and providing it to USDOL, you will receive periodic updates about, things like the portal going live, updated Q&As, frequently asked questions about the program, things like that. It's a great resource because you immediately get an email when Maine DOL either updates something on their website or has some news to share with the public. If you scroll down a little farther on this website that I just mentioned, you'll see there are some links that provide outstanding resources. For example, Maine DOL over the past month, certainly over the past 2 weeks since they passed the final regulation implementing this program, the past 2 weeks they've uploaded, they've delivered 2 webinars like this one. They were delivered by the people who are actually running the Maine Paid Family Medical Leave program. And those videotapes or recorded videos of those webinar presentations are available. So you'll see a link on this website, recorded educational webinars. If you hit that link, you can watch a recorded webinar that introduces you to the portal, for example, answers very specific technical questions, and having attended both webinars, participated in both webinars, a lot of the information is very helpful, and you get a sense of how they've structured this program. And they've modeled it after existing paid family medical leave programs in other jurisdictions like Massachusetts, but they're going to be up and running very soon. And if you want to look at what the folks in Maine DOL who are going to be running the program, how they've described this, and in particular the employer's obligations, I'd recommend that you look at those webinars. The other important resource, there's another link farther down on that page that's called Maine Paid Leave Contributions Portal. And if you click on that link, there's a number of drop downs, and there are a substantial amount of resources that Maine DOL has made available. Q&As about the portal, a demonstration of how the portal works. You actually see, they actually walk you through how the portal is going to appear on your screen. Very helpful resources, and I would commend that to you. So Though, accessing that website, looking at some of those resources, critically important over the next couple of weeks, certainly before January 1. Uh, in January, if you're on that Get Acquainted email list, you'll get a notice of when the portal goes live. Once it goes live, if you've watched a demo, you'll be able to register. And by registration, what I mean is you register your business and you identify the uh, designated representatives who are going to be authorized to upload information about your business, make changes to the account. You can designate an HR manager. You can designate an operations manager. You can designate your payroll processor. Okay, if you have a third-party payroll processor, that person can be registered. And the purpose of the registration is to authorize people to upload information and access information about your workforce, about your premium rate, about your contribution, these quarterly contributions, file quarterly reports. That's the purpose of the registration, to make sure that the people who are responsible within your company for coordinating the contributions, filing the quarterly reports are registered and they have access to the portal on behalf of your company. Now, some of you are probably familiar with the fact that although Maine DOL is administering a public program, a program that they administer through the state through a fund that's going to be administered through Maine DOL. The regulations in the statute that's been passed allow for something that's referred to as private plan substitution. The thought is that there are insurance carriers that are licensed by the Maine Bureau of Insurance who um, early in 2025 will be offering the option to have them administer your paid family medical leave responsibilities. Okay. And so a lot of those, I know for a fact that a number of carriers that uh, principally carriers that provide various forms of disability insurance coverage already in the main market are developing offerings that they're going to make available, and um, so those offerings are going to be available very soon to employers. And starting in April 1 of 2025, if you wish to substitute your participation in the public program to a private plan, one of the plans administered by a third party, like an insurance carrier, uh, or a trade association, something like that, you'll have that option. And there's going to be a very formalized process by which um, an employer removes themselves from participation in the public program and participates, makes their contributions through a third party. That's private plan substitution, and that is an option that is going to become available through an application process that you'll have to make with Maine Department of Labor as of April 1. And then, as I said, these premium contributions and the reports about your workforce, your wage levels, things like that, are going to have to be filed on a quarterly basis. And for employers in Maine, the very first time you have to make your quarterly contribution into the program fund is at the end of the first month following the the first quarter. So the first quarterly contribution, your contribution of premiums for the first quarter of 2025 has to be remitted through the state portal no later than April 30th of 2025. And that deadline for remittances and the filing of quarterly reports will go on from there. So it'll be 30 days after the end of the second quarter, you'll have to make a contribution, and then 30 days after the end of the third quarter, assuming that you continue to participate in the public program, in the public fund. If you apply for and you're authorized to participate in a private plan, the situation is going to be different. It's going to be handled by whoever your third-party administrator is. Next slide, please. Okay, then into 2026. Okay, are there going to be changes or tweaks to the program or to the regulations? Possibly. We have a new legislative session coming in January. There may be some amendments that folks are already considering to the program. We don't know how that's going to play out. But the best thing I think that Brian and I can recommend is to stay tuned. Add an email so you can to the get acquainted list so you can get information and updates from Maine DOL. I'm sure the MMTA is going to keep you abreast of developments if there are any amendments or tweaks to the law. But I don't anticipate that this is necessarily static. And of course, as we get closer to the date that you see on this slide, when the benefits go live in May of 2026, there are now, there are going to be a flurry of communications from Maine DOL. And as we understand it, they're going to set up a separate portal as we get closer to May 2026 that are intended for employees. Okay, to coordinate the application process. They're going to set up a separate portal, and as I understand it, the Maine DOL has already issued an RFP, and they're collecting proposals. They've sent out a request for proposal from vendors who will set up that portal. So I understand that there's going to be an employer portal, the one that goes live in January, and then there'll be a separate portal for employees, and that'll principally be used for purposes of employees who want to apply for these benefits to upload their information. Next slide. Okay, so let's talk about the nuts and bolts of the premiums, the contribution rates. So your obligation to start setting aside these monies as of January 1 and then make that first quarterly contribution by the end of April 2025, the premium level depends on the size of your workforce. So if you're a small employer or a self-employed employer who decides to opt into this, small being less than 15 employees, what you have to set aside is a half a percent of the amount that's of your entire workforce's gross wages. So you calculate what half a percent is on your employees' gross wages, and that's the amount that has to be remitted every quarter. And if you have less than 15 employees, as I said, that entire amount, that entire 0.5% that you take, that you're required to contribute, can be deducted from employee gross wages. Okay? Now, for larger employers, okay, you have to set aside more. Larger employers have to set aside an amount that's equal to 1% of your workforce's or employees' gross wages. And of that amount, you have the option of withholding half of that. Okay, so 0.5% can be deducted from employees. Okay, and again, those monies have to be set aside and accounted for beginning January 1. And you'll contribute that. There'll be a direct deposit requirement through the portal. So part of the registration process is going to involve you identifying a bank account, okay, from which the direct deposit can be taken. That's part of the registration process, but that monies will have to be set aside beginning January 1 for the contribution, the first quarterly contribution later in 2025. And as I said, these premiums are going to be paid into the fund. Every main employer has to do it starting January 1. If you opt for a private plan, then conceivably the second quarter of 2025, your vendor, the carrier, whoever the private plan administrator is, will be coordinating those contributions. But the monies you have to determine that. You have to start making account for that now. And if the plan is that you are going to withhold half of the amount from an employee's wages, okay, you need to let your employees know that prior to January 1. So if they're going to be subject to a new payroll deduction, you can't do that. You can't give them that notice retroactively. And since the monies have to be set aside January 1, they need to be given notice before the end of the year. And ideally, you need to give them at least 7 days notice. Okay, so this is if you plan on taking the 0.5%, okay, for businesses with more than 15 employers, it's your call, it's your option. You need to notify your employees of your intent to do that. If you have fewer than 15 employees, the presumption is that the entire amount, the entire 0.5% is going to be taken directly from your employees' wages. Again, you have to notify them that this deduction is going to start showing up on their paychecks in 2025. And there's no specific form of notice. It should be in written form, and it should make reference to the payroll deduction associated with Maine's paid family medical leave program. Pretty straightforward, but you need to make sure that everyone who is meets that definition of a Maine-based employee gets that notice if you plan to take that 0.5% deduction. Next slide, please. This is an example. I've adapted it slightly, but this is an example that Maine DOL put out earlier this year just to give employers and I suppose employees an idea of what the deduction is going to look like. Okay, now, so we have what this table shows is it shows if you look at the 3 rows that run horizontally, you'll see 3 levels of gross wages. You'll see the first one is where the gross wage level is about $35,000. It's at or near Maine minimum wage for a full-time employee. The next one is an average wage, just below the state's average wage, which is right around 58,000, maybe a little higher than that. That's an average wage for a full-time employee in Maine. And then you have a high-income person, a person that makes $90,000 a year. It can be hourly, it can be a salaried person. It doesn't matter. Then if you go to the second column of this table, you'll see what that 0.5% payroll deduction is going to look like for a person at that income level. So a person one of your full-time employees who's earning at or near minimum wage, if they're subject to that 0.5% payroll deduction, that means that about a little over $3 per week is going to be taken out of their pay starting January 1. Okay. And on an annual basis, it equates to about $175. And you can see as the employee's average wage goes up, the amount of that premium deduction and what it amounts to on an annual basis goes up. So this gives you an idea, and it gives employees an idea of what they can expect to pay in the form of a deduction if they're, in beginning in May of 2026, in exchange for these deductions, they'll have an opportunity to claim benefits if they need it, apply for benefits, paid family medical leave benefits if they need it. Next slide, please. Okay. Who's entitled to benefits? Okay. The definition of eligible employee is very, very broad, as is the definition of employee for purposes of determining whether you are an employee that's above that 15 employee threshold or below it. Okay. So every one of your employees, except for independent contractors. So people who are bona fide independent contractors are not covered, but all your employees are covered. Maine-based employees, whether they're full-time, part-time, salaried, hourly, seasonal, temporary, everyone gets counted for purposes of determining the size of your workforce. Okay. So if you're a sole proprietor or you run a small business, you own a small trucking company, you're self-employed, you can opt into the paid family medical leave program. It's your call. You can elect coverage. You will do that through the portal. There's a special place in the portal where self-employed individuals can register, make contributions out of their own pay. But it's optional for self-employed individuals. But again, there's a very broad definition of who is an employee. Again, it's employees whose wages derive from Maine. Okay. And it encompasses just about everyone that carries the status of employee, whether they're full-time, part-time, seasonal, salaried, hourly. They're all part of that mix. Okay. As I said previously, once the program goes live, they can take benefits for up to 12 weeks per benefit year. As I said, the program is paid family medical leave. Okay. And so in terms of the leave that can be taken for an employee's own serious health condition or the serious health condition of a family member, and that's defined on this slide. One of the things that they've added to the statute and the regs talk about is the definition of family has been broadened. Okay. And it's been broadened so it encompasses persons who have a significant personal bond to the employee. So, in other words, if you have someone that you're not necessarily related to by marriage, someone that doesn't fall within one of the traditional categories, but who lives in your household or that you support, that meets this definition of a person that you have a significant personal bond to, if they experience a serious health condition, you may be able to apply for medical leave, for paid medical leave, to take some time off so you can care for them. So again, a little bit of an expansion of the definition of family in this new statute in the regs. And in terms of where the benefits for this paid leave are capped, across the board, it's going to be capped at 100% of the Maine average weekly wage. That's currently just a little above $1,100. That goes up a little bit every year. But, there is a cap on the benefits. It's not a dollar for dollar amount that comes out of, that the employer has to pay. Again, this is the amount of benefits that an employee who participates in the program may be eligible for, but there is a cap. Next slide, please. more program details. There's an eligibility requirement. As I said, you have to be based in Maine, or the work you have to perform your work in Maine. Your base of operations has to be in Maine if you're an employee to qualify for the program. But there's also a minimum income threshold. In other words, you can't necessarily have someone start for you on January 1 and then apply for paid family medical leave benefits 2 weeks later. There's this individual employee eligibility threshold, and it's somewhat similar to the threshold that gets applied for determining if an employee who leaves your employment is eligible for unemployment insurance benefits. But here's the calculation. So once one of your employees has earned 6 times the current prevailing Maine average weekly wage, and they can show that they've done that in at least 4 of the last 5 completed quarters immediately prior to the first day of the current benefit year, they're going to qualify. And right now, I want to say that's it's about $6,500 per quarter. So theoretically, if the person owes, it's about $6,500 or maybe closer to $7,000 in at least 4 of the past 5 completed quarters, they're eligible to participate in this program, so long as they satisfy all the other eligibility requirements. Being based in Maine, as I said, they can apply for benefits, and they can begin that application process in May of 2026. There is a 7-day waiting period, sort of a carryover from the Maine's workers' comp program. So the thought is the employees that have PTO, banked PTO time or vacation time or sick time potentially could use some of that bank time to cover that waiting period. Then their paid family and medical leave benefit would start after that. In terms of job protection rights, that's going to be carried over from the current program. And once an employee has at least 120 days worked with you, they're eligible to be restored to their previous position or a substantially equivalent position when they return after their period of paid family medical leave. And then there's, as far as the actual application process goes, there is a provision in the regulations, and again, this will become very much more relevant as we get closer to May 2026. But there is an opportunity for an employer, when they become aware, when an employee provides reasonable notice that they need to take family medical leave and they're going to apply for this paid benefit, there is going to be an opportunity as part of the notice process and the application process for an employer to claim what's called undue hardship. Okay, so if the way the program is going to be administered, once an employer receives reasonable notice from an employee that they're requesting paid family medical leave, that they're going to take a period of time off, if the scheduling of the leave or the duration of the leave could pose an undue hardship on the operation of the business, either from a financial standpoint, an operational standpoint, there is going to be a mechanism that allows the employer to negotiate with the employee either to take their family medical leave at a different point in time or an opportunity for the employer to negotiate with an employee for a shorter leave period. This is how the undue hardship exception is going to work. It's not, as I understand it, going to allow an employer to deny an otherwise eligible employee the opportunity to take family medical leave, but it's going to be a manner. It's going to allow a negotiation in terms of the details of the family medical leave so as not to create a substantial operational or financial burden on the company. As we get closer to the application process, when the benefits actually go live, I think we're going to get a lot more guidance from Maine DOL on this undue hardship exception. Next slide, please. Okay, I've beat this drum enough. Okay, in terms of action items right now, highly recommend that you enter an email for your HR manager, your CEO, the operations manager on this get notified list so you get ongoing updates from Maine DOL on the portal, on the program. They're doing a very good job, I would say, in terms of addressing questions, technical issues that are coming up, and the best way to get that information almost in real time is to provide your email address on the Get Acquainted list. That's the first thing. The next step, I've already talked about it. Decide and announce to your employees before January 1 if you plan to take that 0.5% deduction from their wages. If you're a small employer with fewer than 15 employees, you can take that 0.5%, and that will satisfy your premium contribution obligation under the program. If you're a larger employee, you can arrange to have your employees contribute up to half of your 1% premium contribution obligation. But if you're going to begin taking that deduction in 2025, let them know before the end of this year. Okay. And again, there's no magic language or form. Put it in writing, indicate that, beginning in January 1, 2025, you plan to take this payroll deduction, and it's in connection with Maine's paid family medical leave program. Okay. Next slide, please. Okay. Some technical issues that have come up. These are questions that I've gotten a lot in the past couple of years or the past couple of months. Some of these I think I've already answered. The first one that's common is, we're an out-of-state business. We're not incorporated in Maine. We're registered to do business in Maine, but we're based in Pennsylvania. We're based in Michigan. We have a couple of employees who are based in Maine. What does that mean? We have fewer than 15 employees, just a few people in Maine, but the bulk of our workforce is outside of Maine. And we're not incorporated in Maine. We're not a Maine LLC. Are these people covered? Do we have to participate in this program? Yes, absolutely. If you have one employee who performs their work in Maine, or their substantial base of operation is in Maine, meaning that there's an office, whether they work from their home or not, they're eligible potentially to participate in the program, and you need to make contributions related to that employee. So even if you're an out-of-state business with just a handful of people in Maine, they potentially can apply for this benefit, and you have to start making those quarterly contributions as of January 1. Or setting aside the money for your quarterly contributions January 1. Okay. The next question. We're a Maine-based business, and we have a bunch of employees who work remotely. We have a CFO that works out of their home in Massachusetts. We have other people, salespeople, regional salespeople. They never come near Maine. Are they covered, and do they count toward the 1%? No. No, they do not. If you're a Maine-based business, but you have employees who work remotely. All the work they do for you is performed outside the state of Maine. Our position is that they're not covered and they don't count toward the 1%. So as you're determining what what the total gross wages for your workforce, your covered workforce are for purposes of applying that 1%, remotely based employees who don't have any connection with Maine, don't perform any work in Maine, they're not covered. Okay. The next one, our final pay period of 2024 straddles the new year. So in other words, our last pay period, for example, runs from December 24 through December 24, 2024 through January 7 of 2025. How do we calculate the 1%? Maine DOL has made that really easy. If the money is paid in 2025, that's the amount that you calculate the 1% against. Okay. So that eliminates this issue of trying to prorate for pay periods that straddle the end of 2024 into 2025. And it also eliminates the issue of, well, we're paying out a bonus in 2025, but it was for work performed or sales that were generated in 2024. Is the bonus compensation encompassed as part of the 1%? The answer is if it's paid out in 2025 to the employee, it all counts toward the 1%. So then the question becomes, well, what is there anything that isn't counted toward the 1%? I mean, what's the definition of wages? Gross wages. It is very broad. And for most employers and in most employees, there's very little, if anything, that's going to be backed out. So base compensation, whether it's hourly or salary, is included toward that aggregate amount against which the 1% is going to be based. Bonus compensation, commissions, the traditional forms of pay, whether it's paid weekly or quarterly, that's considered wages. Okay, there's very, very little that gets backed out. And, if you have a technical issue or something along those lines, or if some of the compensation that you pay employees is in kind or in lodging or something along those lines, my recommendation is you reach out to Brian. Brian and I can consult and I can give you some very specific guidance on whether or not the value of whatever that compensation is, whether it needs to be included in the gross wages or not. Okay. This is the last question. There are a lot of questions that have come in on what I call top-off issues. One of the questions that come in is, so this paid family medical leave is a partial income supplement. Okay, it's not intended to cover 100% of what an employee typically takes home for the period of leave. So the question that comes in is, can employees be required to use up their PTO, their banked leave, sick leave, PTO, vacation leave, before they apply for paid family medical leave benefits? And the answer is absolutely not. The state does not allow an employer to say, well, you have to use up your paid banked leave before you're authorized to apply for paid family medical leave. You cannot impose that as a mandatory requirement on your employees. So then the related question is, can we require our employees to use their PTO to top off their benefit? In other words, if the paid family medical leave benefit pays 60 or 65%, of what they typically earn? Can we compel them to make up the difference, that 30 or 35% from their bank leave? You can't compel them to do that, but you can't, if they want to do that, you need to give them the option to do that. You have to require your employees to do that. Okay? But if they want to do that, you need to give them the option of doing that. Next slide, please. More technical issues. Okay, can we require our hourly employees to contribute 0.5%, but exempt our salaried people from doing it? Or can we require our part-time employees to contribute 0.5%, but not our full-time employees? The answer to that is no. Once you decide whether you're going to have your employees contribute that 0.5% or not, okay, you have to do that consistently for everyone who is covered under the program. Okay, you can't do that. There's a very limited scenario involving employers who are subject to multiple collective bargaining agreements. If anybody falls into that category, I can get into more details about that. But for the most part, once you decide whether you're going to take that 0.5% or not, and I know some employers are not doing that. They're going to pay the full 0.5% if they're small, under 15 employees. They're going to pay the full 1% if they're larger, if they have more than 15 employees in their workforce. But once you make that decision, everybody in your workforce who falls within this program has to be treated the same way. When can we expect Maine DOL to increase the 1%? What we're hearing from Maine DOL in the legislature is that 1% contribution rate is going to be locked in through the end of 2027. So I know there's been a lot of discussion amongst employers and other groups worried about whether Maine DOL is actually going to be able to fund this program. But at least for right now, Maine DOL is locked into not increasing that 1% contribution rate between January 1, 2025 and the end of 2027. After that, all bets are off. Where can I get more information about the program and how it's going to work? Earlier in this presentation, I laid out that website. I really want to give a lot of credit to Maine DOL. They've done a good job of putting a lot of very valuable information, educational information, demos. Brian has just put it up on the screen. If you scan down a little bit, there's the Get Acquainted link right there, the box on the left-hand column where you can enter an email address to start receiving emails. Brian, if you go a little farther down, along the right-hand side there, you see those web links I talked about. There are resources for employers. There's the last link there is the contribution portal. There's drop down all kinds of information in PDF form about how the portal is going to work. There are demo options there. If you're a payroll processor, a third-party administrator, if you're an employer, there's all kinds of very specific guidance. And so, my strong recommendation, as I said earlier, is don't wait until, midway through January or the end of January. But, if the portal has gone live, get up to speed in terms of what information you're going to have at your fingertips when the portal goes live, and then go through the registration. Give some thought now to, okay, who's going to be our designated representative? Whose contact information are we going to upload into the portal as part of the registration process to input information about our business or access information, ask questions, communicate with Maine DOL. It's important to think about who those people are going to be. It doesn't necessarily have to be one person, but their contact information is going to have to be uploaded as part of the registration process. And it's important to think about that now and to familiarize yourself with what that database, what the portal looks like. I think they've done a pretty good job. And by all indications, it's going to go live early in January, if not on January 1. So I think that's where we are right now. Brian, have you seen any questions come up in the portal? Pardon me, in the portal, in the chat?
So I haven't in the chat so far. So I did figure out this has been our first webinar in a long time that you do have the ability to raise your hand, and I can allow you to talk and ask your questions, as is typical of our group. I've had questions texted to me,
Yeah,
so our
makes
folks
sense.
don't follow direction very well. Um, One question that I got is, can an employer require employee attendance for employees that are on leave if reasonable? The example they gave was the employee is taking leave for a spouse who had knee surgery, but they don't need 24/7 care. And my sense is the answer to that is going to be that it's going to have to go through the undue hardship provision that's still taking shape. But I'll let you be the lawyer.
Yeah. So there is under the current family medical leave program, and this is going to continue for paid family medical leave. There's a type of leave called intermittent leave, so it's conceivable that a person may qualify for family medical leave because their family member or they themselves have a serious health condition. It doesn't mean they can't work at all. It just may mean that for 3 hours a week or a couple of hours a day, they want to be excused from work. Okay. And and under the Paid Family Medical Leave Act, it envisions that for those periods of intermittent leave, an employee can can apply for and receive this benefit, so they don't have to use, for example, their PTO or their main earned paid leave to cover those absences. Does that get to the question, Brian?
I believe so, and if not, that person can put it in the chat.
Yeah, I mean, the issue with the undue hardship is that I think it's far more likely that the undue hardship exemption is going to apply in situations where an employee wants to take leave and their plan is to take 10 full weeks or 12 full weeks, and their request comes at a time of the year, for example, where it's very operationally difficult for the employer to accommodate somebody being out 10 weeks or 12 weeks. Or the person, by virtue of their job, by virtue of their expertise and the ability of an employer to replace them, simply can't afford to have that particular person be unavailable for a 10-week period or a 12-week period. And as I understand it, that undue hardship exception is going to allow the employer to begin a conversation before the leave actually starts with the employee to try to negotiate that, to try to manage that so it's less of an operational or financial burden for the employer. Now, how that plays out when we get closer to May of 2026, we're going to learn a lot more about what Maine DOL intends and how this is actually going to be implemented. But right now, from my standpoint, it's important for my clients to understand the undue hardship option is not intended to enable you to say, Brian Park, because of what you do for us or because of the size of our operation, I'm sorry, you simply can't take paid family medical leave. It's not that's not the intent. Um, And
So
but
I'm probably a bad example because I think most of my members would say I'm pretty much expendable. But yes, your point's well taken.
yeah, think in terms of for those of you who are familiar with this paradigm, think in terms of the reasonable accommodation discussion that you have with people who are disabled employees and they need something, some accommodation in order to perform their job. There's an interactive dialogue between the employer and the employee in terms of what that accommodation is going to look like. And in terms of what type of accommodation is reasonable, I'd say the undue hardship exception, at least as I understand it, is going to sort of parallel that discussion.
Yep, good. Uh, Still yet nobody has raised their hand. This usually isn't a bashful group. I know that when if you're a member of our self-insured workers comp trust, we had a presentation done
Mm-hmm.
earlier this year, and the fine folks at Acadia were generous enough to put that on for us, but they weren't lawyers, and now we have a lawyer here that can answer a lot of the legal questions. So,
One
Susan
thing, oh,
Giroux,
that
I am
reminds
gonna.
me of one thing that I
Oh,
didn't bring
go
up,
ahead.
Brian,
Okay.
and this is important. It's you'll see it reflected on the website that I talked about that I directed you to. It's also referenced in the regulations. There is a posting requirement. Okay, so there not a heavy lift. But there is a posting requirement. All main employers need to. You can go on that main DOL website. There's a downloadable posting. It's a one-page posting. It's the Family Medical Leave Law. Um, it's a description of the program and the benefit. It needs to be posted in a conspicuous place. If you have a, you know, you know, in a main based location where your employees work, whether it's a break room, if you have a main based employee who's working from home, send them a written copy of this. There's a posting requirement that you have to put up right with the other postings that you have in your workplace, and and I'm sure that through the association, Brian talks to you about where to get those postings and which postings have to be up every year. So this is a new posting requirement. You can access it, print it out, post it in a conspicuous place where the employees can see it. And related to that, the regulations obligate all main employers as part of a new hires onboarding process or orientation process. Every new hire is going to be required to be briefed about the paid family medical leave program. I think the easiest way to do that is when you have a new hire, as of January 1, after January 1, every time you bring a new employee on board, whether they're part-time or full-time, as part of the onboarding process, they got to fill out an I-9 form. They have to fill out benefit election forms. They have to give you a W-4 form. Okay, so how many for purposes of employment tax and withholdings. As part of that paperwork process, give them a copy of your employee handbook and give them a copy of this paid family medical leave poster that satisfies the requirement that you have to provide in written form information about that paid family medical leave benefit. So anyway, I don't know if there are any other questions, Brian.
Yep, there are, and somebody pointed out that technical difficulties from yours truly. I didn't enable the chat. It is now enabled, but Susan Giroux has her hand up, and I am allowing Susan to talk. So go ahead, Susan.
Hey,
Great.
Brian.
Hi,
I just,
Susan.
how are you?
Good.
Good. I have a couple of questions, so I apologize. First off, on the 4 points, those questions to
Yep.
determine if an individual is a main employee,
Yep. Yes.
say I get 1 through 3, I'm answering no. But the last one says, does the individual perform some work in Maine and live in Maine? If I
Okay.
answer yes to number 4, does that mean they are
So yeah, so it's a sequential test.
okay?
You've answered no, so they're not performing work in Maine. They don't have a base of operations in Maine, okay, a primary location from which they start work and come back to return regularly. Um, the their services are not directed or controlled from Maine, and that leaves place of residence. And I'm reading from the reg and the guidance provided by Maine DOL. If none of the above criteria apply, and the employee performs work in Maine and other states and resides in Maine, then Maine law applies. If none of the above apply, the employment is not reportable in Maine. So that would tell me that, and again, I think that's a very unusual circumstance. I think that you know, if the employee performs a very, very small amount of work in Maine, but their work is not directed from a location in Maine. They don't have there's no base of operations in Maine, and but they have a very tangential link from a job performance standpoint, but they live here. They may be eligible for the program, but in my travels as someone that has hundreds of clients, some of which are based in Maine and some of which are based outside of Maine, it's a pretty unusual situation. I mean, it's conceivable, but as I said, Susan, I I I'm happy to have a conversation with you about the details so I can help
Okay.
you navigate this. And you can, my email address is available, I think, through Brian.
Okay,
But
good.
I haven't had in the past couple of months many clients where I've had to cycle down through that sequential test to the fourth criteria.
Okay. And then I
Next
just have,
question.
yeah, sorry. So let me ask you this. Box 1 on the W-2 for the employee, is that reduced out of their taxable wages, or are they paying tax on the deduction if they're doing the 0.5%?
This is that's a great
It
question.
is.
This is the one the 0.5% is taken from gross wages. It's a great question. That's a highly technical question. I don't want to freelance it. Let me
Okay.
follow up. I'll get the answer to Brian. Brian, you can blast it out to everyone.
Yeah, and I actually saw that one on one of the FAQs on their site. Our wages for paid family
Oh,
medical
okay.
leave
Yeah,
calculated pre-tax or post-tax. The answer is premiums are calculated on total subject wages before federal income tax, state income tax, Social Security, and Medicare
there you
taxes
go.
are deducted.
Pre-tax. Pre-tax.
Okay.
So
And that's right on the site,
there,
Brian?
It is
Okay.
in
not
in
surprising,
their FAQs.
not surprising, Susan.
Okay. And my
They
last
they've got
question.
they have 17 months to seed basically the funds for this program, and so yeah, I guess that makes sense. Yeah,
Yeah.
again, the FAQs are very comprehensive, and it's a kind of my guess is those FAQs, uh, Brian, you probably saw that in the FAQ section. It was part of the employer resources link. Yeah,
Correct.
so yeah,
Correct.
okay,
Yeah, it is number 5 on the
perfect,
FAQs. Yeah.
excellent, thank you.
Awesome. Thank you. Then my
That
last question is, and maybe this is in here and Brian saw it or someone saw it. So our truck drivers, they have per diem incorporated in their wages.
Yes,
Is that going to be classified under gross wages?
yes, I would say it is. Yes,
Okay.
yes, it is. Yep, yes, yeah. Pretty clear to me that per diem compensation would be part of gross wages. Yeah.
Okay, so we do exclude those wages from workers' comp.
Yep.
Totally different though, right?
Yeah,
that's
it
that's
is.
for premium calculation.
Yeah,
This
It,
is for income tax,
yeah,
right? Yeah.
for the
yes,
funds.
yeah, yeah.
Okay,
There's not there wouldn't be a deduction for per diem paid
okay,
to employees. Nope. Yeah, it's the definition of wages is not taken from the definition of wages under the workers' comp program. It's taken from a different. It's taken from the unemployment insurance statute. So it is included. Per diem
okay.
compensation is included.
Okay, you all
Okay.
set, Susan?
I am. Thank you very much. I
Wonderful.
appreciate both
Thanks,
of your
Susan.
time.
Thank
Thank
you.
you.
Question came in, and it's kind of similar to one of the ones that Susan asked. If an employee lives outside of Maine, but the employer is based in Maine, do they still have to contribute? This employer has employees that sometimes reside in Canada and sometimes reside in the US.
Does the employee perform? Does the employee that so the business is the base of operations is in Maine? Does the employee perform any work? Do those employees perform any work in Maine? And if the answer is yes, then the state takes the position that their wages are related to work that is done in Maine these are wages that are related to work that is performed in Maine and they would count. But if these folks, if it's a Maine-based company and the employees at issue don't do any work in Maine, don't have any link to Maine at all, they don't perform any work in Maine at all, they would not be covered.
Okay. And if that doesn't answer your question, put it in the chat and or raise your hand. Another question is, can you discuss the requirement to hold someone's job for them while the employee is on leave?
Yes. So that can be that's a really troublesome, challenging obligation that employers face, and really, it's the obligation is it's referred to as a job guarantee or a job restoration right, and the idea is if an employee who's eligible for family medical leave, and in this case, paid family medical leave, so long as that employee is prepared to return to work and perform the essential functions of their job um, when they return prior to the expiration of their entitlement of leave, what the employer is obligated to do is return them to their previous position, all the terms and conditions and that existed at that time, title, compensation, benefits, all that. That's really historically that's been the fundamental legal protection that's been associated with the family medical leave program. It becomes challenging, and it has historically become challenging for employers to manage that, to navigate that requirement, particularly for folks who are out for 10 weeks or the full 12 weeks of family medical leave. And that's going to continue when it's paid family medical leave. And what I have historically, and this is not this is me um, providing a recommendation to my clients based on liability risk considerations. Um, you're not there. There's nothing that restrict. If you know somebody's going to be out and they're going to be out for 10 weeks or 12 weeks or whatever, and that's going to create a problem, and you have to replace that person. You have to bring somebody in, whether it's a temp, whether it's a new hire, then you have to do it. You have to do it. The law doesn't say that you have to keep that position vacant. The challenge you face, of course, is if the person, if your prior employee who's eligible for family medical leave is prepared to come back at the end of the 10 weeks or the 12 weeks or whatever, you're going to have to get rid of the person that you hired, or what you're going to have to do is displace that person, the new hire, and give the employee who took leave their previous position. What I see some employers trying to do is they say, well, the new hire that we brought in is doing a great job, and it's got a great attitude, is very productive. And you know what? We'd rather have him than the guy that's coming back from leave. And well, how do we deal with that? I think you deal with it at your peril. If your plan is we're going to somehow manage the situation where that person is not brought back, or that person is brought back, but in a new position that pays something substantially less, you're opening yourself up to liability, serious legal liability. And the better approach is to return the employee who took the leave back to their previous position, performance coach them so they get to the level of performance and productivity that you expect. And the new hire, the person that's doing a great job that you want to keep in your organization, find something for them to do, but don't displace the person with the leave rights, with the job restoration rights. It's a significant challenge. 20 times a year I deal with, and I work with clients to try to navigate that. It's really challenging, but the cases and the US DOL and Maine DOL are crystal clear in terms of their expectations. You have to offer a person coming back from leave their previous position or a substantially equivalent position. And substantially equivalent is very narrowly defined. So that's a great question. And it's an ongoing challenge for my clients.
Okay.
What else, Brian?
One other question. I'm going to do this at my peril, but Mr. Doyle.
Yep, there he is. Hi, Tim.
Hey, how are you?
Good.
Was there a question, Brian?
Well, you had your hand up, so I'm recognizing you.
I didn't mean to. I may have hit it inadvertently. I apologize.
See, this is
Nice job today.
Tim, do you have any criticisms or
No,
comments?
I already cut him off. I cut him off probably 10 times a day. So, actually, I have one final question. I don't see. Oh no, now we've got more hands up. So I'm going to go to Emma Chamberlain. Emma Chamberlain.
Hi, Emma.
You are up. And
Okay,
yep, there we
I
go.
just have a quick question. If we have a subsidiarity under a parent company and the subsidiarity has less than 15 employees, but the parent company has more, does the employer still have to contribute to the subsidiarity company?
So let me ask you a question. Does the subsidiary have its own federal employer identification number?
Yes.
Yes, it does. Well, no. Then it's the law treats every entity that has its own federal employer identification number as a separate employer. So both the parent and the subsidiary would have to register as separate employers. Okay. And they'd be treated as separate employers. So if the subsidiary has less than 15, it would be subject to that lower premium contribution rule. It would have to register its employees, its information, and then your other entity, the parent with more than 15 employees, would have to register itself separately and would be subject to the higher 1% premium contribution rate. Does that
Even
make
if,
sense?
yeah, even if the owners own both of the companies the same?
Yes.
Okay,
Yes. Yes.
perfect.
Yeah, the MDOL has made very clear that they're going to define employer based on whether the entity has its own FEIN.
Okay, that makes sense.
Emma,
you.
thank you for that
Thanks, Emma.
question. You actually asked the question that I was going to wrap things up with, because at MMTA we have a couple different FEINs. So thank you for that. And I'm going to go back to Susan Giroux.
Sorry, one more question.
Susan's coming
No
back
worries.
for more.
I am that per diem, that one's gonna hang me up. So the per diem incorporated into the truck driver's wages. We don't incorporate that on state unemployment.
Okay, let's do this. Let's have a conversation about this offline. That'll
Okay,
give me an opportunity to. So, Brian, if you can make sure that Susan has my contact information. So, Susan, I want to have an offline conversation, and then I'll loop back with Brian, and if it's something that is something that might be relevant for his other members, you can
Great.
circulate that. But
Yep,
thank you.
perfect. And the way we're going to handle that, and Susan, I will do that. I will do that as soon as the webinar ends. We're going to have a page for just paid family medical leave where this recording is going to go on it. And I'll also post the link to the FAQs and the way to sign up for the get notified list through MDOL. We'll have a separate page for all that. If there's things like what Matthew just indicated, if the offline conversation with Susan is something that we need to let all members know about, that's where that will be located as well. But I've got going on an hour and a half here. Matthew, we really appreciate the time that you've spent. Looks like there are no more questions either in the chat and nobody with their hand up. So I want to thank you for being with us today, and thank you for all the useful information.
thank you. Thanks to everyone. Okay. Have a nice holiday.
Thanks, you too. Take care.
Okay. Bye-bye.
Bye-bye. Bye-bye.